real estate investment deed. Get ready because it's time to raise the stakes with real estate. Like with any other specialized area, real estate has its own specialized terms and definitions. Terms and definitions we need to know in order to communicate properly within the field. We're going to be looking into the definition of a deed here, noting that we're going to be referencing Investopedia so that you can look up more information with regards to terms and definitions that are investment related. So we're looking at the deed which can be defined as a signed legal document that grants its holder ownership to an asset but may set a number of conditions on the transfer of the title. The deed is not a title. Instead, it is the vehicle for transferring a title. So when we're thinking about land in particular, we're thinking about real estate, things that are permanently attached to the land and things that are permanently attached to it. We can't move the land. The land is where it is. We need some way to define who has ownership, who has title to the land. That's going to have to be done with documentation and through some kind of legal process. The deed helps us to do that. It helps us to transfer the land, but the deed itself isn't title because there could be conditions in which people can argue or dispute the particular deed. There could be different types of deeds that we'll take a look at shortly, and there could be other claims that could be claimed against the deed, even though there's a deed that has then been transferred. Note that when you think about land, of course, you can think about really kind of unusual type of circumstances with regards to ownership and title over a long period of time, because obviously the land's been there for a long period of time, and you need to be able, in order to determine title, to track the ownership and what has happened with regards to the changing hands of ownerships over time to determine who legally has the rightful claim, the rightful title to the property. Again, the deed can help to settle some of those kind of disputes. So it is the deed. If the deed is not written, notarized, and entered into the public record, it could be open to legal challenges and delays. So obviously, if the deed isn't written, it's going to be a lot more difficult to like prove it in a legal situation. If it's not notarized, then you don't have that second verification. There's going to be less insurance to it. And if it's not entered into public record, what you want is for the deed to be entered into public record generally, because if someone else is making a claim, they're going to be making a claim based on the information that is public record. And again, the land is where the land is. So you need to basically claim that is your land in a public way, and public record generally will help to sort out those types of claims who actually has ownership to it. So if those things aren't there, then it could be more likely that they're going to be open to challenges and delays. There are three main deed types. There's the grant deed, the warranty deed, and the quitclaim deed. So let's take a look at those shortly. We got the warranty deed, a document often used in real estate that provides the greatest amount of protection to the purchaser of the property. So typically, if you're purchasing the property, you want the greatest amount of protection. So you're basically looking for, generally, we have a warranty deed. The deed pledges or warrants that the owner owns the property free and clear of any outstanding liens, mortgages, or other encumbrances, other problems on the property that could cause you people to make claims against you once you are the owner of the property. So things, of course, that could cause problems is if there were, liens on the property, mortgages, and so on, as you took ownership of the property. So the grantor is responsible for a breach of any warranties and guarantees, therefore placing a great amount of risk on the grantor. So note the grantor then, the one that's going to be taking on, in essence, the responsibility in that case to give the purchaser here the greatest, support, as they have the warranty deed, that they have, full claim to the property, clean and free. So it's a document often used in real estate that provides the greatest amount of protection to the purchaser of the property. It pledges or warrants that the owner owns the property free and clear of any outstanding liens, mortgages, or other encumbrances. We then have the special warranty deed. A special warranty deed is a deed in which the seller of a piece of property only warrants against problems or encumbrances in the property title that occurred during his ownership. So notice the lowering of the bar here. So it's a little bit lower here. So if you're the purchaser and you're purchasing it from someone else, the someone else is saying, hey, this it's free from anything during the time period that I had it. But obviously the property is quite old property because it's land. So the land's, it could have a history beyond that. So it's possible that you could have claims that would basically go on beyond the ownership, of course, of the prior individual that you are purchasing from. So once again, a special warranty deed is a deed in which the seller of a piece of property only warrants against problems or encumbrances in the property title that occurred during his ownership of the property. So if there's a problem prior to that didn't really come up during his ownership or something, it's a prior claim or something like that, that's where there still could be, in essence, a problem. And obviously you can think of different circumstances where this may be, higher or lesser assurance. Obviously, if they owned the property for a year, that wouldn't, it'd be less assurance than if they owned the property for the last, 50 years or something like that. Then you would think they might have a bigger claim. But in any case, a special warranty deed guarantees two things: the grantor owns and can sell the property, and the property incurred no encumbrances during his ownership. The special warranty deed is more limited than the more common general warranty deed, which covers the entire history of the property. Then we have a trust deed, which is a little bit different. It's basically a trust. You can see the trust, which indicates that third party that could be involved. So in financial real estate transaction, trust deeds transfer the legal title of a property to a third party. So there's that third party in the trust component of the trust deed, such as a bank, escrow company, or title company, to hold until the borrower repays the debt to the lender. Trust deeds are used in place of mortgages in several states. So this could be dependent on the state that you are in. We might talk more about this scenario in future presentations. Lastly, we have the quitclaim deed. A quitclaim deed releases a person's interest in a property without stating the nature of the person's interest or rights, and with no warranties of that person's interest or rights in the property. A quitclaim deed makes no assurance that the grantor actually has an ownership interest in a property. It merely states that if the grantor does, they release those ownership rights. So it's just going to be the releasing of the rights. They're quitting the claim in essence. When might you be using this? Quitclaim deeds are typically used to transfer property in non-sale situations, such as transfer of property between family members. So if it's a sale type of situation, you would think a higher level of deed or higher level of assurance would be necessary. If it's between family members and a non-sale type of transaction, it might be easier just to have the quit claim, and it may put less obligation on the person that's giving the property from one family member to the other.